LLC is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Angie, and thank you, counsel, for agreeing to participate in this oral argument via Zoom. This is a work in progress each and every time we do it, and sometimes we do really good at it and sometimes not so good, so just bear with us as we go throughout this process. A couple of things before we get started. First of all, I want to introduce your panel for this morning. We have with us Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. And we have our deputy clerk, who is basically running the show today. She and Mr. Jim Hibner, the clerk of the court, have been trained to do this. And so we have Angie Dempsey, the deputy clerk, assisting us today. And want to thank her for her work in putting all this together, and also the work of Mr. Hibner. I also want to thank the AOC's technology staff. They make all this work. I don't have any idea how they make it work, but they make it work, and we appreciate it. So everybody, I assume, understands how we're doing this, but just for my own purposes, each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you need to request that from the court, but after you introduce yourself, but before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
Kelsey Light versus Pattman, LLC, DBA Wendy's Restaurant.
We will hear from the appellant.
Good morning to the court. My name is Brian Walhart. I represent the appellant, Pattman, LLC, and I'd like to reserve 5 minutes for rebuttal.
All right, sir, you may proceed.
May it please the court. This morning we're here on an appeal from a denial of a motion to compel arbitration, in which the trial court held that the arbitration agreement, the written and signed arbitration agreement, did not clearly waive the plaintiff's right to a jury. We believe, and we think the law supports the conclusion, that that is an error under the facts of this case. In this agreement, I'd like to quote to the court the agreement before I start with my argument. The arbitration agreement clearly states that it, quote, applies to all disputes involving legally protected rights, e.g. local, state, and federal statutory, contractual, or common law rights, regardless of whether the statute was enacted or the common law doctrine was recognized at the time this agreement was signed, end quote. And that by signing the agreement, the parties understand, quote, that by signing this agreement, that I am agreeing to substitute one legitimate dispute resolution form, arbitration, for another, litigation, thereby waiving any right to have my dispute resolved in court, end quote. We believe that this language clearly waives plaintiff's right, number one. Number two, we believe that Tennessee law supports that there's a binding contract under these facts. And number three, we think the facts and the totality of the circumstances is in keeping with the policy that favors arbitration agreements. Here, we believe that the FAA, the Federal Arbitration Act, applies because my client is a Kentucky limited liability company with its principal office in Kentucky, and it operates a Wendy's restaurant in Tennessee. Plaintiff, on the other hand, is a resident of Tennessee and did all the work there. In this particular situation, we've talked about the express language of the document. We've talked about what the trial court held, and Tennessee law is clear. And even if you do apply—
Counsel, let me stop you there just a minute. What did the trial court hold?
That the arbitration agreement does not clearly waive the right to a jury to a person of limited education.
Okay, and correct me if I'm wrong, but weren't there a plethora of defenses asserted as to this arbitration agreement?
There were, yes.
And was there a evidentiary hearing held?
No, Your Honor.
Okay, so the trial court read the agreement, said just from a reading of the agreement, the plaintiff couldn't understand it.
Yes, and well, there was an affidavit submitted by the plaintiff. The plaintiff argued that she had an 11th grade education. She talked about the circumstances surrounding her signing the agreement. Those included the fact that it was an online application, that she enlisted the help of her boyfriend to help explain it to her, that she could not specifically remember which portions of the arbitration agreement that she read or looked at. She said she couldn't remember reading anything regarding the signing of the agreement. She said that she, after the fact, read the agreement and doesn't understand it. And we think that those facts make it so that the court can analyze the facts de novo, because plaintiff can't say that she even read the portion of the agreement that's at issue here. So whether she
Counsel, let me ask you a question about that. Does the court even reference the that it relied on the affidavit or even read the affidavit in the order? The order is kind of sparse. But it does say that without resolving any factual dispute.
Yeah, well, Your Honor, yes,
and it didn't take any evidence. So I mean,
well, that could be another reason, Your Honor, why it's an error here. Here, this language is just crystal clear, and to me, that this idea that it can't be any clearer, it clearly says that they're waiving any right to even have this dispute resolved in court whatsoever. Even in 11.
Let me stop you just a minute, counsel. So, in your opinion, these waivers are absolute, right?
Well, I do think there's some other factors that court can consider, but in this particular case, yes, I think it's absolutely clear that plaintiff waived her right to a jury trial. Well,
all right, let's parse this out, as a colleague of mine used to say. You've got all these defenses that have been raised that the trial court never addressed because the trial court essentially relied upon this finding. Let's say you're correct, just for purposes of discussion. What happens?
Well, I think that because it's a contract, it's contractual language, it's objectively clear, the court does have enough facts to analyze the totality of the circumstances of the signature. And since this is a de novo analysis.
I don't think you understood my question.
I don't. I'm sorry.
Okay, let's try it again. You've still got all these defenses that have been asserted outstanding. Doesn't the trial court, at a minimum, assuming that you're correct and that there's no way the trial court could have made this finding, isn't the trial court required to go back and examine the remaining defenses before anything goes forward?
Well, Your Honor, I would argue that.
No. Look, this is a yes or no answer.
No.
Okay, no. And why? Why?
Because because all of the necessary facts are before this court. It is a de novo review by this.
The trial court never ruled on the remaining defenses.
That is correct, but what I am asserting, Your Honor, is that the court can, under the law, everything is undisputed, all of those defenses can be resolved at this level. And because the standard is de novo, the court does not have to go through and make a determination as to each and every one of the asserted defenses by a defendant. For instance, the argument that the name of my client wasn't used in the arbitration agreement, that can be easily resolved here because there's no legal requirement that a written contract contain the technical legal name of a party under Tennessee law. For instance, the idea that my client did not sign the agreement, we have submitted the agreement. There's clearly not a signature, but I have submitted case law and argument showing that courts routinely enforce arbitration agreements that have not been signed. And so while it would have been preferable, admittedly, for the court to go through and make rulings on all of these matters, since this is a de novo standard, the court can look at the agreement, look at the facts that were submitted, and apply them to this scenario.
Well, that's part of the problem, I think, and I think that's what Judge Stafford's alluding to here, is that the court said it wasn't resolving any facts, and it wasn't looking at any facts. And aren't these determinations of arbitrability by the court? We talk about unconscionability or oppressiveness or unreasonableness. How do you decide those without looking at facts? He didn't even have an evidentiary hearing. I don't understand how you look at that in a vacuum without listening to facts and looking at facts. Maybe you can. That's the problem I have with it.
Well, I think there's two separate questions. You're asking me how the court can make the decision it did, and I can't answer that question because of the court's ruling is what it is. My only recourse once the court rules is to come before this court on my absolute right to appeal a denial of a written motion for arbitration and say that the facts that were submitted to the court and the language in the arbitration agreement is sufficient to show that there is a waiver of a right to a jury trial here and that arbitration is appropriate.
No one's questioning your right to appeal what the trial court did. What we're trying to ascertain is what happens if we believe that you're correct. And that is whether this has got to go back for the trial court to reconsider those issues or whether we can make that decision. Honestly, I believe that at a minimum, it's got to go back if you are correct, because we're an appellate court. We review what the trial court does. We don't make that initial decision.
Well, I think here the language of the arbitration agreement is undisputed. The facts that were submitted by plaintiff are undisputed at this stage. But nothing was fact. This is all, the record is before the court. This is all clear. And to me, the standard is a de novo standard, Your Honor.
All right, you've used your time. You still have your rebuttal time. We will hear from the appellee. And why don't you go ahead when you feel the need in your argument or have the opportunity in your argument to address just what we've discussed. Don't want to tell you to run your argument, but I would like to hear your thoughts on it.
Okay. Yes, Your Honor. My name is Allie Hargett. I represent appellee Kelsey Light. And I guess I will start off and then jump back to your question if I may.
Go ahead.
Just to mention that it's really important here that we think first and foremost about contract formation and the importance of that with arbitration agreements. Because even though arbitration agreements have been favored in the past in Tennessee, a plaintiff cannot be forced to arbitrate something that they did not agree to. And that all comes down to contract formation. And in Tennessee, of course, there has to be a meeting of the minds, and there was no meeting of the minds here if we're looking at the typical contract formation principles.
So why was there no meeting of the minds?
Sure, Your Honor. There was no meeting of the minds whatsoever because defendant did not even sign the agreement. Defendant's name was not even on the agreement. There was not a signature line for the defendant. The plaintiff has a very limited education and did not understand at all what the agreement says. She doesn't even remember seeing it. And also there's a few unenforceable provisions within the agreement. One of the most important unenforceable provisions in the agreement is a cost splitting provision. And this cost splitting provision says that each party is to bear their own cost.
Well,
that wasn't even addressed.
Go ahead.
I mean, that's not even mentioned in the order. That's one of the things that Judge Stafford is talking about, that there were a number of defenses raised, but they weren't addressed, and the court didn't have an evidentiary hearing. How would you even address a defense like that without having an evidentiary hearing to discuss cost of arbitration, any number of things?
Yes, Your Honor. I can't really speak for how the trial court ruled, why they did what they did, but what I can say is that looking at the order, they looked at the arbitration agreement itself and the affidavits that were submitted, and then made the decision based off of that. And that is what we have to work with here. And the order, as you said, is very minimal, but it said what it said about denying that motion for arbitration, and that is just all we have to go off of right here at this time. So it's important to look at the blanket statement there. The bottom line was that the arbitration agreement was denied by that court by looking at the agreement itself and also those affidavits, which state those important things, such as the plaintiff has a very limited education, has a very limited.
Okay, here's a good place for you to answer my question then. You're asserting things that I'm sure you asserted to the trial court, but the trial court didn't rule on it. So let's assume that we determined that the trial court didn't have a good basis for what it did. What happens now?
Well, Your Honor, if that would be, are you saying that if you determined that it should go back to the trial court, is that what you're asking?
Well, the opposing counsel says this court can make those determinations and that we should make those determinations.
Mm-hmm. Your Honor, we think this court could absolutely has the power to make those determinations de novo, as opposing counsel stated.
How would we do that? As Judge Golden just alluded to, you have asserted a defense that the cost of this matter is prohibitive. There are a plethora of cases out there, and Judge Golden just wrote one that some of us participated in. And he talks about what needs to be proven in the trial court if we're to consider that issue. Nothing was proven in the trial court regarding any of that, as far as I can ascertain. Perhaps it was, and I missed it. So what happens?
Your Honor, I can't answer that definitively. I suppose all we have to go off on is what the trial court ordered. It was very minimal, and it was looked at in a very minimal way. But we do think it was because there was minimal things to look at the time. So we do think the trial court looked at everything that they could have and that they needed to in order to make this decision. So we do think it's right that it's here before you today to go ahead and uphold that decision and affirm that they did look at everything that they needed to, including the agreement and the affidavits, and made the correct decision based on looking at all the appropriate measures. So I will jump back into, and maybe this will further answer your question as I continue to explain a little bit of what our position is, that back into that call splitting provision, which would just render it completely unenforceable. A lot of agreements will have a severability provision that can take this kind of cost splitting provision out of it, but our agreement didn't have that at all. And so this cost splitting provision is stuck into this agreement, and it's unconscionable and unenforceable. The courts have looked at these provisions in the past and looked at potential litigants such as our client that have very limited income, work in a minimum wage job, live paycheck to paycheck, and see that these costs are just not possible for plaintiffs like ours to bear the own costs that these types of agreements that the defendant is attempting to enforce.
How can we address that? That's not even mentioned in the order.
Mm-hmm. Yes, Your Honor. Well, it's mentioned in the way where the order addresses the limited education and
where did that come? The court doesn't even say where that came from.
Mm-hmm.
That's a fact. The court says it's not resolving any facts or factual dispute. Now, maybe there's no dispute about that. I don't know, but we don't know where that came from. You can't tell from the order where it came from.
Yes, Your Honor. Well, all we have to look at is that order, and the order just.
That's all we have to look at. That's all we have to look at.
Yes, Your Honor. And the order says that they considered that plaintiff's limited education and disparate nature. So that is one thing that we can pull from the order, saying that they used those facts to.
Ms. Hargett, the order says that the court was left to decide the issue raised by the briefs and oral argument. And the order doesn't say that anything else was considered as to your client and her specific means or her specific situation. Are you saying that that evidence was presented?
I believe it was in the briefs, included in the briefs, Your Honor.
But are you saying it was presented to the court?
Excuse me, I'm sorry.
What do you mean you believe it was included in the briefs?
All of the necessary evidence about explaining the client's means.
Briefs aren't evidence.
Yes, Your Honor, you're correct, and there wasn't an evidentiary here. Yes. I guess what I'm alluding to is that the order just deferred to what it did, and that's all we have to go off of. That's all you have to go off of, as you just stated. And that I understand what you're saying is it's hard to make a decision based off of that order, but that's the only thing that we have in front of us is to look at what it says and to uphold it or not to uphold it at this point. And we believe that the trial court did everything they could to put what they could in that order to say that it was not upheld and that it was rightly not upheld based on what they looked at in the briefs. So I would continue just to point out that there has been a similar case to ours, actually just before this court in August of this year, where there was the trial court found that the motion to compel arbitration should not go forward, just like it did in our case. This was the Stokes v. Allenbrook nursing case back in August of this year in front of this court, and that court had a severability. That case had a severability clause, whereas ours does not. So whereas the court held there that the unenforceable provisions could be separated and make the agreement okay, we do not have that type of severability provision.
I'm just curious. Was it ever pointed out to the trial court that there was no severability clause in this particular agreement?
I do not know right off the top of my head, Your Honor. I believe it was in one of the briefs. I do not have that brief right in front of me.
Okay.
Let's see. And the next thing I just wanted to point out, Your Honor, I know I'm getting down to the 5-minute mark, but I just really want to reiterate that the agreement itself is what's the most important thing here. That is the very document that we're arguing about. And the agreement itself does not have the defendant's name or signature on it. This court has found that assent to a contract is shown by the signature of the parties. Without a signature of the defendant, this is not a valid agreement. There was an electronic signature of our client, but again, our client does not remember looking at it, does not remember signing it, had to have the help of her boyfriend to get through all of the documents, and then there was still no signature of the defendant. And even if there was one mention of the company, that is not a specific enough name to be able to identify who the defendant actually is in this case. It had no mention of the defendant's name, Pattman, LLC, in the agreement itself or on the website where the plaintiff applied for this job. There was no indication that this was actually the defendant. Our plaintiff did not know who she was signing an agreement with. There was absolutely no identity there. And such an ambiguous identity is not enough for a court to say that there is a valid contract agreement. Another thing I wanted to point out is that, again, the plaintiff's disparate position is a thing that has come up a lot. And the plaintiff here essentially had an agreement presented to her in the job application process. It was presented to her on a take it or leave it basis. It was presented to her.
Again, did the trial court make a determination as to whether this was a take it or leave it agreement?
In the order, they did not, Your Honor.
Okay, so where does that put us? Because I'm assuming that there would need to be some evidence regarding a take it or leave it agreement.
Yes, Your Honor, and the evidence would be the agreement itself. So the trial court based its ruling just off of the agreement and the briefs there. So the agreement itself would be, again, the most important piece of information. And that, if you look at the agreement on its face, it was something that was in the job application spread that the plaintiff had to click through every piece of document in order to finish applying for the job. If she didn't finish clicking through all of those documents, she wouldn't be able to apply for the job. She was desperate for a job. Again, she works paycheck to paycheck. She just had to click through all of these documents to get there. And
that sounds factual to me.
Yes, Your Honor.
You've given us facts.
Mm-hmm. Yes. Well, these are just all supporting this law, where this court has found that those take it or leave it bases agreements are not enforceable, and this court has found that on multiple occasions. And this is just a very similar situation to those other cases where an agreement was given to a party and that party had no bargaining power. The party, like our plaintiff, has had no chance to make adjustments to it. She had to just take the agreement as it came to her with this language that she had no understanding of. For instance, the language in there that she had no understanding of, it does not mention trial, it does not mention jury. Those are common terms that a layperson would need to hear to understand that her rights are being given away. Our plaintiff had
Ms. Hargett, all of these purported facts that you are alluding to, how were they presented to the trial court?
Through those briefs, Your Honor.
Through the briefs.
And the oral argument.
And that's what the court based its ruling upon was the contents of your briefs?
That is what I understand, Your Honor.
Thank you.
Yes. And Your Honor, just to further prove that point, that the contents of this agreement are just not something that a plaintiff in our shoes could understand. And if that is the case, then again, there's no mutual assent. This cannot be a binding agreement on a plaintiff with such a limited education and such a disparate position as ours. It was not a clear and knowing waiver at all of any rights to a jury trial. So, Your Honors, I think that the main point to take away from this is that there's not a valid contract here. There is no binding agreement between the plaintiff and the defendant, Pattman, LLC. Again, no name of the defendant on the contract. And considering the limited education, our plaintiff had no idea what she meant when she signed it. She doesn't even remember looking at the agreement. So for these reasons, we would ask that you do uphold the trial court's ruling denying the defendant's motion to compel arbitration. Thank you.
Thank you. Okay, we will hear rebuttal from opposing counsel. You may proceed.
Thank you, Your Honor. To put a finer point on this, these facts were not introduced in briefs. They were introduced by affidavits from both parties. So there is sworn facts in the record. With regard to the contract formation agreement, we've cited the TR Mills case. There's absolutely no requirement that there be a signed agreement by both parties. Conduct can manifest assent. Here, that's what happened here. It is undisputed that plaintiff showed up for work at the store, worked, and got paid. So this idea that there was no agreement it just isn't supported by the facts, and plaintiff signed it. In Tennessee, there is prima facie, that's prima facie evidence of an agreement signing a contract. With regard to the quantum of proof necessary, Your Honor, I think it's appropriate. Since the parties did produce affidavits and they did produce facts to the court look and say the plaintiff did not carry her burden of showing that she has a cost. She has not met her burden of showing the cost splitting agreement would prejudice her. She hasn't produced any bank statements, any bills that she pays, her rate of pay, and that's that. Furthermore, with regard to this cost splitting agreement, frankly, plaintiff is incorrect. We've submitted a federal case out of Texas where the courts have severed a cost splitting agreement, even though there wasn't a severability clause in the contract. That is done, and that is legal here. And furthermore, to the court, a record was submitted from the American Arbitration Agreement showing that the employer would bear all of the costs of arbitration, I think, except for maybe a $300 filing agreement. With regard to plaintiff's education, Your Honor, I'd like to say that I don't think it matters that she has limited education here. And the reason why that doesn't matter is because of the case of Advantage Windows versus Zacharias that we've cited. In that case, we had someone who didn't speak English signing a contract that was written in English. And this individual claimed that the contract was not enforceable because he didn't speak English. The court said, sorry, that's not enough. That's not sufficient. You signed the agreement. Here, plaintiff signed the agreement. Plaintiff didn't understand what it said and what it meant. She shouldn't have signed it. Again, the agreement is plainly states that she can't even go to court on her case. And so this idea that she doesn't understand what that means, the undisputed facts in the record by plaintiff's own affidavit is that she has an 11th grade education, that she manages a restaurant. That's what she does as her profession. That's something where if someone looks at you and says, by the way, if you sign this, you're not even going to get to go to court on your case. I know exactly what that means. That we don't need an evidentiary hearing to go beyond that. Your Honor, to circle back around, Your Honors, to circle back around, you're very concerned about the fact apparently that there wasn't a hearing with live testimony and with evidence submitted to the court other than what's been submitted. I would submit that it is appropriate to decide the case on the record because both parties have submitted signed affidavits under oath stating the facts. And our position is that with those facts before the court can assume, in fact, that they are undisputed under the current law. You can assume the fact that she has an 11th grade education. We're not disputing that. You can assume the fact that she works as a manager in a restaurant. But here, what is also undisputed, and plaintiff doesn't dispute, is that she signed this agreement. She signed it with the language. She doesn't even remember reading this provision. She had someone else fill out the paper for her and sign, and she can't even remember signing it. She doesn't know which portions that she read. Another Advantage Windows, that's in favor of my client. You can't go around signing documents and later call foul because you had your boyfriend fill it out online at home. She had as much time in the world as she wanted. She even conscripted help. She could have gone and had the opportunity to get some help interpreting this if there was something she in fact did not understand, which by the way is exactly what she did. Plaintiff didn't submit an affidavit of her boyfriend. She didn't submit any of her income information. She didn't submit any of her bills. Here, the policy is in favor of arbitration. In this case, should be arbitrated. There's sufficient facts before the court to make that determination. And with that, Your Honor, I'll rest unless you have a question for me in these 20 seconds.
See no questions. We appreciate you participating in this process. Again, I want to thank your clients and each of you for doing that. We will endeavor to get you an opinion at the earliest possible date. Thank you for doing this. And with that, Angie, I believe that will conclude the call to the docket for this hour. We'll be in recess until the call to the 10 o'clock docket.
Court is in recess until 10 a.m.
Thank you.
Thank you.